And right now we are going to speak with Aaron Van Allen, professor of government at Liberty University, our normal Monday guest. But with all of the Trump executive orders out there, we thought we'd grab one and talk about it with him this morning. And so we're going to talk about this one where he is going to try to work his way around the 14th Amendment and end what is known as birthright citizenship in the country. And Aaron, good morning. Welcome back to the program. Thanks for joining us an extra time this week.
Absolutely. Brian, Mary Biscuit, thanks so much for having me back this morning.
So let's start out the 14th Amendment, one of those passed in the wake of the Civil War. Tell us, what is the 14th Amendment meant to do, and what is the specific language that is at question in the amendment?
Yeah, so the big item that we see happening here is specifically many what you would consider to be more conservative constitutional scholars. What they would state is that the 13th, 14th, and 15th Amendment are in fact written in Reconstruction. They're written in the aftermath of the American Civil War, but more importantly, they are meant to give those that were freed slaves, those that were to become newly freed slaves as well, to give African Americans more rights, but also to rectify many of the ailments pertaining to slavery in regards to the initial Constitution that was written in 1787, that was then passed officially in 1788, and then that the remaining states came aboard in 1789. And what I mean by that is, say, for example, the importation of slaves to the colonies, there was a moratorium on that, but also the fact that all persons which were in fact slaves under the original Constitution were counted as 3/5 of a person. So the 14th Amendment and all of the various clauses that are established therein, the precedence was initially to inevitably rectify some of the ailments surrounding the issue of slavery, but also the rights of African Americans themselves. So that is a very broad answer with regards to the original intention of why it was actually enacted there.
And so there's a part of it talking about anyone who is subject to the jurisdiction of the United States. If you were born here and subject to the jurisdiction, you are a citizen. But this started in the 80s, I guess. There's a book by a couple of, I think it's like Yale law professors, who are saying that doesn't necessarily apply to people who are here illegally, or if they're the children of people here illegally, they are not subject to the jurisdiction of the United States. Is that the same argument that Trump is making?
Yeah, that's exactly what Trump is doing. And so Trump's actually going a little bit further. Trump is saying that just because you were born on American soil, that even if you have a parent, or even if, let's say, for example, that one of your parents is in fact a citizen, but the other one is in fact an illegal citizen, then you are not a citizen of the country. So he's even breaking it down even further within this executive order. What he is stating is that he claims that the United States is the only nation on the planet in which, if you are born on American soil, i.e. you were born within the continental United States, or you were born within a territory or some reason, i.e. subject to the jurisdiction thereof, that you are automatically an American citizen. The dichotomy that Trump has going on here is one that inevitably scholars, academics, but also those that are legal scholars as well, just to be more specific, that they're continuously debating on this topic is the following. When you say subject to the jurisdiction thereof, are you merely referencing that the laws of the United States are, in fact, ringing true there? And so, henceforth, if the law of the United States is superior within that specific geographic region, you are protected, or you are automatically a citizen if you were born on that soil. Or, and this is what Trump is arguing here, Trump is stating that, no, you are subject to the laws thereof in that specific area. And so what Trump believes is that by signing this executive order, he can merely state, you know what, I'm changing the law. This is no longer the case, and henceforth you are subject thereof of this new executive order that I have inevitably signed. I personally or professionally believe that that is way too tall of a task for him to overcome in rewriting the 14th Amendment in that way, and more specifically that clause, merely by signing an executive order. You have to remember that the 14th Amendment is inevitably when you have the vast majority, as the Constitution requires, you have the vast majority of the Congress that passes it, and then in modern terms, if you wanted to have a constitutional amendment, you would have to have 38 of the 50 states actually ratify it. Well, that was the same thing that the 14th Amendment, not 38 of the 50 states at that time, but that was the same very tall constitutional requirement the 14th Amendment had to overcome. So for the Congress and for the will of the people via the states to say this is what we believe, for Trump to come in and say, I'm going to dislodge this precedent merely by executive order, I think he's going to have a lot of trouble in court with that.
Speaking with Aaron Van Allen, Liberty University professor of government, here on the Morning Line.
Would the president have it apply retroactively?
I don't know that he, and I will point this out, that I'm not a JD, I'm not a lawyer, but from my historical analysis, I don't know that he could do that retroactively, i.e., say, for example, that you show up in the United States legally. For example, you overstay your visa and now you're here illegally. Or let's say, for example, that there's a law, for example, that you show up at the border when President Biden is the president, you claim asylum, and legally you can do that. And then you overstay that asylum, that asylum visa, if you will, or that asylum status, and henceforth you were in the country illegally. If Trump were to try to say, for example, retroactively go back and say, okay, you know what, actually that asylum law was illegal and we can no longer do that, I don't know if he's going to start flirting with ex post facto laws or bills of attainder, which are completely unallowed and are completely prohibited by the American Constitution. I don't know if he has the legal authority to do that, but I'll reserve that more to the legal scholars themselves.
Now, there is a case from about around the turn of the 20th century where this prospect was at least to my layman's view, tested out. This is when Chinese immigration was not necessarily illegal, but they could not become citizens. And you had the child of Chinese immigrants who was claiming citizenship, and he won his case before the Supreme Court. Does that precedent still hold?
Yeah, I mean, there's numerous precedents that people are going to be debating here, and the court case that you may be referencing there was a case that was decided by the Supreme Court in 1898. That was the United States v. Wong Kim Ark. That could have been the case, one of those that you may have been mentioning, Brian. But
yes, that's the case.
So you could reference that case, but it actually begins much, much further. You can go all the way back to, say, for example, the mid-19th century itself, where there was a lot of disagreement which was coming forward about the citizenship status of freed slaves themselves. And this is where you get to the Dred Scott v. Sanford case that was decided in 1857, where the Supreme Court said that descendants of slaves could not, in fact, be citizens themselves. Now, after the 14th Amendment and the Citizenship Clause is inevitably passed, this is where you see that the Congress, more specifically, and I think that it's very important that we reference that. It's not the courts, it's not an executive, it's the Congress. And the Congress, if it passes something, it inherently is obviously statutory law, but it is going to hold the most weight. It's the reason that the American framers made Article 1 of the Constitution 4 times larger than Article 2, and Article 2 twice as large as Article 3. But you get to the Dred Scott decision, and then you have the Congress that is starting to move things back. So therefore, in the adoption of the language of the Citizenship Clause itself, what you see is that the 39th Congress of the United States was trying to return to essentially what was known as a pre-Dred Scott common law rule. And what that rule was saying is that birth within the United States conveys United States citizenship itself. And so you start to see the Congress taking up pieces of legislation time and time again. That is where you start to have all of these various debates which are occurring. It ultimately culminates in the U.S. v. Ark decision from 1898. And this is where the United States Supreme Court, in that decision, that they reject a challenge to the citizenship of a man who had been born in San Francisco, California, to parents who were ultimately Chinese nationals. And what had occurred within that court case is that ARC had left the United States in, I believe it was 1894 or 1895, to return to China. And then when he got back to the United States in, I believe it was August of 1895, he was actually detained by the Port Authority within San Francisco, but also specifically who was known as the Collector of Customs at that time period, stating that he could not, in fact, gain entry back into the United States of America. So this case here, and then the court later on within this case stated the following. They explained that, quote, clear words or manifest intent, end quote, of the citizenship clause confers citizenship upon, quote, all children here born of resident aliens, whatever race or color, end quote, of their parents or whomever is their guardian at that time period. So that 1898 decision really establishes a lot of the precedents that we have. And then from there, you have numerous other court decisions that inevitably establish that precedent even further, stating that, well, even if your parents are not here legally, then if you were just merely born on American soil or in a territory subject to the jurisdiction of American law, then you're inherently a citizen.
And so this is just a bit of speculation on my part, but I'll see what you think of it. Obviously, the administration is not going to try to change the Constitution. That's why we see in the executive order. And it seems that what they're hoping to get out of this is, I think that they'll probably lose in lower courts because of precedent. But you get to the Supreme Court, and maybe the Supreme Court is willing to narrow past rulings, maybe from the 1898 case or something like that. Do you think that is a reasonable possibility?
I absolutely think that that's the case. I think what the Trump administration is going to try to do here is they're going to try to do the exact same thing that they were doing with this current court. They're going to try to do the exact same thing that they were doing with the Dobbs v. Jackson Women's Health decision when they kicked that back to the states themselves. And they're going to come forward and they're going to say, we have new evidence. And part of that evidence, again, within the abortion argument, was they brought forward science. And they said, we now know what is that science has changed, and science has, in fact, changed the idea of what is considered a viable embryo or a viable fetus, if you will, is what the law literally states. So henceforth, we have to make a new decision. But more importantly, what they were saying within that case is that not only Roe, but decision like Casey, for example, in the 1990s, that had to be relitigated. I think they're going to do the same thing here, where they're going to go back and say, well, it was too broad. There was a lot of overbreadth in the language. They actually didn't have standing to begin with. Here's the historical analysis. I think that they're going to break it down so deep. And you've already seen, say, for example, the state of New Jersey, as well as 18 other states that have come on board and made a similar argument, stating that there's a common law heritage to this issue. I think that the Trump administration is going to say, yeah, sure, there is, in fact, a common law history here, a common law precedent, and that is why we think that this decision needs to be, this executive order by the president needs to be upheld.
All right, 7:22, and we'll leave it there. Aaron Van Allen, professor of government at Liberty University. Thank you for joining us this morning.
Absolutely. Thanks for having me back, guys.